You're muted.
Okay, same thing happened to you, happened to me, I guess. Okay. All right. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. All right. This is an interstate case, so Mr. Larkins was not required to be here. Ms. Correa, go ahead and proceed.
Your Honor, we first like for you to take judicial notice of Mr. Killingworth present in the courtroom.
So noted.
And, sir, we are approaching today because we have a contested reset date. It is my understanding that the father wants time to discuss this case with an attorney. The OAG does not object to that. He is wanting a 90-day reset, and we're asking for a 30-day reset.
Okay. Were you here when we had our last court date, Mr. Killingsworth, in March?
That's a negative, Your Honor.
What's that?
No.
Okay. Okay, I can give you 2 months. Um,
Your Honor, at this present moment, I am in between jobs. I am also in between interstate transition myself. I am not in the state of Texas. I am
Your
currently
Honor, I'm
back.
going to object. This goes to the merits of the case.
yeah, I mean, if you want time to hire an attorney, that's all I'm really trying to hear right now. But I mean, your other stuff, I mean, that's something that you would have to tell me at your court hearing. You were living in Texas, correct?
It doesn't matter at this point, apparently.
Well, were you? I mean, I'm trying to help you, sir. You're not helping me help you.
All right, guys. The courtroom opens with tension in the air. The judge swears in the witness as the defense fumbles with technical issues. The father, Mr. Killingworth, wants 90 days to get an attorney, but the state only allows 30. The judge questions his presence and quickly realizes things aren't adding up. As he struggles to answer simple questions, his excuses begin to irritate the court. The tone shifts fast. This isn't going to be a friendly conversation.
Were you living in Texas?
I was.
Okay. You'd recently moved?
Not by my own will, but yes.
I don't need the details. Did you move or not?
Yes, that's why I need an attorney.
You need an
Someone
attorney
that
because you can't answer
can.
questions?
Well, the thing is, I can answer the questions, Your Honor, but the questions that you're asking on a basis of your own merit, which are
No, I'm
pertaining
not.
to
I'm
this
asking you,
particular matter.
have you lived in
I
Texas?
need
The
an
answer is
attorney
very
to be
simple.
able to
Either you've lived in
verbalize
Texas.
and
Excuse
to
me, sir.
articulate.
Sir, I'm talking. I'm not trying to be rude with you, but it's a very
Well,
simple
that's what
question.
you believe.
Have you, okay, you're going to keep talking over me. I'm not going to give you what you want. Okay. I mean, I'm being respectful to you. I'm asking you a very simple question. You want to give me an explanation. Have you lived in Texas? Is a yes or no answer. Doesn't need an explanation. Then my next question was, when you live in
Yes.
Texas? But you can't give me any kind of clear answer. So, I mean, we're going around circles. You think that I'm being rude to you and
No,
disrespecting you, and I'm
what
not.
was your last
You're talking
question?
over me right now, which is very disrespectful. Doesn't convince me and persuade me to rule in your favor when you people do that. Okay, it's very
Here's where things get heated. The judge presses him with a basic question. Were you living in Texas? Instead of answering, the father spirals into unnecessary explanations. The judge stays firm. He wants a straight answer, not excuses. When the man keeps talking over the bench, the judge fires back hard, calling out the disrespect. The courtroom's energy changes. What started as a reset request becomes a lesson in control and courtroom conduct.
simple. I understand you got a lot to say, but you're the one saying, I don't want to talk today. I want to go talk to an attorney. So I'm not going to get into a long discussion of you trying to tell me stuff when it isn't going to help me, it isn't going to help
Well, Your
you,
Honor,
and it
I'm
isn't going to
giving
move us
you
along. Because
the
if you want
basis,
to
Your
hire an
Honor.
attorney, then what you need to do is go talk to your attorney. Maybe they can teach you about respecting a judge and how you're supposed to behave in court, and they can direct you as to what you're supposed to do. I'm
Your
going to
Honor,
give you a reset, but you want to argue a whole case, and I'm not going to do that. You either want to
I'm
go forward
trying
today and
to
we can
give
talk
you
about it
the
today,
basis
or we
of
can reset your
why.
case, and or I can just get upset with you and not give you a reset at all. So do you want
That's
to
the law.
reset?
Is that the law?
Do you want to reset? She
Yes.
can't answer simple questions. It's simple
I
questions.
said yes.
Is the sky blue? Well, no, I don't know. It's maybe it's yellow
Well, on
today.
my
Maybe
side
it's
of the state,
green.
my
It's
side of the
either it's
country,
blue
yes, the
or it's
sky is
not.
blue.
I'm not trying to be rude with you, but it's a simple question. You want to reset?
Listen up. This is where the hammer drops. The judge lays it out clearly. You said you want an attorney, so stop arguing and go get one. He reminds the man that talking over the court never wins sympathy. The defendant keeps circling around simple yes or no questions, testing the judge's patience. Finally, the judge warns him keep acting out and there will be no reset at all. The man folds, mumbling agreement. The authority in the room is undeniable.
You can't answer the question.
Man, you tripping. I'm
I'm
trying
not
not to
tripping.
go there.
Okay. All right, let's Miss Correa, pick a date 2 months out.
Seven 16/25.
Okay. All right, I'm giving you till July 16, 2025 to be ready. If you're not ready or you don't appear again, we're going to do an order without you. So
And
you
my
notice that
question,
you're here.
my question,
Stop talking while I'm talking. I really do hope you find an attorney because they're going to tell you that you got to respect the people that are going to make decisions in your case. I'm going to make a decision one way or the other. I want to make it a fair decision based on the law, but you want me to persuade it that I shouldn't because of the way you're acting. So think about that.
Right, so the verdict's clear. The judge grants a 2-month reset till July 16th, 2025. But before ending, he drops wisdom that hits like a gavel strike. Respect the people deciding your case. He tells the man to fix his attitude and come back prepared or face judgment without representation. It's not just about legal rights, it's about respect, responsibility, and courtroom discipline. One final command echoes, bring a better attitude when you come back. Case reset.
I'm going to listen to you, but you say you want to hire an attorney, go hire an attorney and have them and ask them all the questions you need about your case, and we can move on. But otherwise, we're going to move forward on July 16th. Bring a better attitude when you come back. You're done with court. You can press leave on the Zoom to exit out. Thank you. You're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, the court notes Jonathan Knight was served January 15, 2025. He has not filed an answer. Mr. Williams, go and proceed.
Thank you, Your Honor. We're here on a motion to modify. I would like the court to take judicial notice of the previous order and suit affecting the parent-child relationship entered May 28, 2024.
So noted.
In the previous order, Your Honor, the father was incarcerated and so support was not set. So we're looking to go ahead and set support today with the new information we have for him. May I proceed?
Yes, sir.
Your Honor, at this time I'd like to call the mother, Valerie Mina. Can I get you to state your full name for the record, please? You're talking, but I can't hear you, Ms. Mina. Are you connected to audio?
Hold up. The courtroom doesn't rest. Another case begins immediately. The judge now calls Jonathan Knight's case for modification of child support. This time, the attorney steps up, calm and precise. The father was previously incarcerated, and now the court seeks to set support based on new income. The mother, Valerie Mina, is sworn in this time. The tone is respectful, the process smooth. The tension shifts from chaos to careful order.
Okay, now I have you as mute.
Okay. Hello, Valerie Mena.
Thank you. Thank you, ma'am. Thank you so much. Now, can you give me the name and ages of the children we're here for today? You're back on mute, Miss Mina. Can I get you to unmute?
Okay, now it's letting me. It was saying I couldn't unmute.
No worries.
now-
Can I get you?
Okay.
Can I get you to give me the names and ages of the children we're here for today?
Yes, Lindsay Mena, age 12.
Thank you so much. Now, in the previous order, the father was ordered to pay you child support. Is that correct?
Yes.
Now, well, I'm sorry. In the previous order, he wasn't ordered to pay you child
no.
support, but found to be the father of the child. Is that correct?
Yes, yes.
He was previously incarcerated,
Yes, he was.
so he's no longer incarcerated. Is that correct?
Correct.
Do you know if he's working?
Yes, he is.
And what does he do?
A car salesman.
Thank you, ma'am. And how is the child currently covered under health insurance?
She has Medicaid.
Okay. So we have wages reported by the employer for him in the amount of $4,137 gross. We're asking for medical support, cash medical support to be set at $63 per month beginning June 1st, 2025 for him to cover the cost of the medical for the child. Would you be in agreement or disagreement with that amount?
In agreement.
Thank you, ma'am. Also, as far as his child support, we had to give him credit for 3 additional minor biological children. Does he have 3 other minor biological children, Miss Mina?
2 for sure that I know of.
2 for sure that you know of?
Yeah.
Okay. Why do you what is the reasoning behind that you know of? Is the 3rd child just a possible, or you don't know for sure?
Yeah, I honestly I don't know for sure, but possible.
Okay.
Yeah.
Okay. So we did give him credit for 3 other children. We had wages reported for his employer in the amount of, as I told you before, $4,137. We're asking that child support be set today at $506 beginning June 1st, 2025. Would you be in agreement or disagreement with that?
In agreement.
Thank you, ma'am. Now, over the course of the past 2 years, has there been any family violence between yourself and the father?
No.
Okay, so are you requesting a non-disclosure of your address and phone number in today's court order?
Now here's where the facts unfold. Valerie confirms the father's employment as a car salesman, earning over $4,000 gross monthly. The state requests $63 medical support and $56 in child support. She agrees without hesitation. Everything seems resolved until the discussion turns to privacy. She asks for her address to remain undisclosed, citing a protective order involving another man. The judge listens intently, balancing her safety and the father's parental rights with surgical precision.
Yes.
And what would be the reason for requesting it if you and the father haven't had any issues?
I'm currently under a protective order with another father of my youngest daughter.
Yes, ma'am. Thank you so much for sharing that information. Your Honor, at this time I pass this witness.
Okay, we can do kind of a partial non-disclosure if that's what you need.
Okay.
When we're talking about, there are kind of 2 non-disclosures. One is where you don't want Mr. Knight to have your address, or you don't want anybody to have your address. So, is it okay if Mr. Knight has your information?
I honestly I don't feel comfortable with that. Just
I'm not asking about if you're comfortable, other than, as you said, there's been no family violence, and
no.
so why should we be scared of Mr. Knight? He wants to probably visit his child.
Okay.
So why would we want to be scared of him?
Just I mean, I just wouldn't want my address being like exposed to like other people.
I get that, and we can do that,
Okay.
but you still would have a responsibility to let Mr. Knight know where you live.
Okay.
So are you okay with, that's what I'm asking you. If you have
Okay.
you have a protective order, another case, no question, I'm not doubting you on that. I'm not,
Okay.
I think you probably do need a non-disclosure for that, but what I'm trying to drill down, I guess, is you need a non-disclosure for Mr. Knight as well?
If I can't, then that's fine.
Other than you just don't like it, I'm not hearing any reason why Mr. Knight
Okay.
shouldn't have your address. So that's what I'm gonna keep asking you.
Okay. That's
Is there
fine.
some reason besides you just don't like it?
Yeah, just no. Yeah, exactly.
Okay. All right. So I'm granting you a non-disclosure as to third parties.
Okay.
Mr. Knight needs to know your address, so you and him are obligated to let each other know where you live. You don't have to make it public so that the other person that's not involved in this case today can get access to it. But you do have to let Mr. Knight know. So if he doesn't already know, text him, email him, send him a letter, something like that, so that he has it. And otherwise, then you can have a non-disclosure as to any other parties. Our
Okay.
default judgment granted as requested. The Attorney General's office will draft an order, and they'll send out a withholding order to his employer. You are done with court, ma'am. You can press leave on the Zoom to exit it. Thank you.
Finally, the judge brings it all home. He questions Valerie's need for non-disclosure against this father, Mr. Knight. She admits she just doesn't feel comfortable, not because of danger, but preference. The judge respects her honesty but reminds her that parents must exchange addresses for the sake of their child. He grants partial non-disclosure, protecting her privacy from outsiders but ensuring Mr. Knight remains informed. With firm fairness, The judge closes court case resolved, order granted.